Good afternoon, everyone, and I hope you're still a little bit awake after lunch. I know this is my time to take a nap if I can. I just wanted to introduce myself a little bit. I have a Ph.D. in chemistry from Johns Hopkins University, did a postdoc, then decided I actually needed some money in my retirement account so I could retire someday. So I went to the government and worked for the patent office, and I worked for the patent office for about 25 years as a primary examiner, and then I was an administrative patent judge for over 17 years. So I know a lot about the patent system. This talk is only 10 minutes today, so I'm just going to hit some high points, but my contact information is on the slide. Feel free to reach out to me by email, by phone, whatever works for you. Oh, I can never figure these out. I just wanted to tell you a little bit about Wilson Sonsini that's pertinent to what you're doing today. We focus on emerging life science companies. That is where our patents and innovations department shines. And we work with a lot of companies as they're coming out of incubators, as they're coming out of universities. We know how to do this. And then we also have all of the other tools that you need as your company grows, and even as you're starting out, including corporate, tech transfer, licensings, and then we help companies all the way through initial public offerings and mergers and acquisition. This is just a quick view of our expertise. We hire a lot of agents right out of the lab. They all have PhDs, and we have over 80 agents. So we have a wide variety of expertise at the firm, and we have a wide variety of clients, and this is just a small collection. So I know nobody likes to talk to the lawyers and nobody wants to pay their patent attorneys. If I can put $30,000 or $50,000 into development, and I can give my patent attorney $50,000, I want to put it into development, and we do understand that. But your IP is the most valuable possession that you have as an emerging biotech company. And very often, it is the only thing that gives you any value whatsoever. So you have to pay attention to your IP from the very beginning. One of the things I'll talk about in a few minutes is if you disclose what you're doing before you actually file your application, you can lose rights, not just in the US, which we have a little bit of you have a year that you can still patent it. But if you want to go into Europe, China, Japan, and other important parts of the world, you lose that. So it's very important to be paying attention to your IP from the very beginning. So you have to get this right. These are just some of the forms of IP that companies will use. Obviously, I do patent law, but I have familiarity with all the rest. And again, I can't stress this enough, patents are the most important. Looking at this a little differently, you can see your protection on the graph on the right, you have protection and then cost. Patents are the most expensive, of course. But the other forms don't give you the type of protection that you need as you're going forward as an emerging life science company. So trademarks, you have to be using them. So you want to trademark your company name, but if you're going to be trademarking a product name, you may not want to do that too early because if it's not in use, you may lose your trademark. Copyright, that's the familiar one. A song can be copyrighted and everything else. It just protects the particular work. It doesn't protect much else. I get a lot of questions about trade secret. Trade secrets are really hard. It's only protected as long as it's a secret. So you have Coca-Cola and you have maybe one or two people who know what that formula is, and that's very important. I have a company that only two people actually understand everything, and they can never be in the same plane at the same time. As your company grows and as more people are doing this, it's very hard to keep a trade secret. Trade secrets can walk out the door. The other thing about a trade secret is somebody else may patent it and then you can no longer use your trade secret. So those are things to keep in mind with trade secrets. That's not to mean that you can't keep your secret sauce, so to speak, to yourself, but we can get a patent that's broader and that covers what you're doing so that nobody else can come into the area. Patents, the term is the shortest term. It's only 20 years from filing. So in some ways, the protection isn't necessarily long enough because we start filing IP before you even have a product. But the other thing that we'll show a little bit later is how we do this in stages so that we can give you the most patent protection for the longest period of time for your product. So your patent strategy enables your business goals. It can take from $350 million to almost $3 billion to bring a new drug to market, and I think we all know that. And another thing you should be considering as you're starting your journey is looking at a freedom to operate search. Patents are very different from publications. Patents can cover things very broadly, not necessarily done. Scientists don't think in the terms of patents. So you want to do your freedom to operate search to see if there's a patent that may cover what it is you're doing. Even though you know what you're doing is very novel, it may be covered by somebody else's patent. And you especially want to know if that's a Merck patent, a Roche patent, or somebody else who are going to very fiercely protect that patent. And with your patent strategy, you want to file early and you want to file often. And you don't just patent your product, you're patenting things around your product. You can patent the method of making, you can patent the method of use. One way to extend a patent term for a particular product, and I think we see this with like Humira or something, you keep patenting new uses. So you continue to file new things to continue to protect your product. And then strong patent protection means the ability to obtain financing. Venture capitalists are going to look at your patent portfolio. And if you do get acquired, it means you get a higher valuation upon acquisition. So those patents make a difference. One question that we get is, what can you patent? Theoretically, you can patent anything under the sun. There has been some changes on that with the Supreme Court law. We have to be a little bit careful around natural products and diagnostics, but for the most part, a good patent attorney can get you around those and get you something that will cover your product. And then preserving patent rights. And this is one of these things I talk to my clients about on a monthly basis, and it seems to go in one ear and right out the other. Before you publish anything, tell your patent attorney. Before you do a talk, tell your patent attorney. Before you do an abstract or a poster presentation, tell your patent attorney. And even things that people don't think about, like clinicaltrials.gov, that gets published, and it is searchable. There are also a lot of grant publications that get published. So make sure you're thinking about not just the things, I'm filing, my paper's coming out in Science next month, do I have to have this protected? But we're filing our clinical trials protocol. Do I need to put this into an application? And this is something that's a little bit hard for scientists, because I think as a scientist, you want to share your work. We're taught to share our work. We're taught to be talking to people. But for the patent side of things, you have to make sure it's in an application before you do any of that. And then my one last slide I wanted to show was this. This is how we structure a patent portfolio. So we start very early on, the first patent family, and that's going to cover your more general ideas. So if you have a platform, for example, you're doing drug discovery, you have a platform, that's what we would put here. Or if you have a general mode of action or a particular target that you're targeting, that might be our platform there, and we start there. We do a second patent family, which protects improvements and the optimized product. As of yet, we're not protecting the actual molecule. We're not doing our picture claim. And then last, we do our third patent family, and if we have our product that we're going to market in, that's what we protect here. Very often, we don't have to lose term over the first patent family, because if you have a more generic disclosure, that doesn't necessarily teach the more specific disclosure. And then added onto that, we can get our potential patent term extension through exclusivity and other things. So, and this is very important, and one thing I wanted to mention is it's important to think about this from the very beginning, because a drug like Keytruda, which we all know is very well worth billions, but it's coming off patent protection in 2024. So unless there are any questions, I'm sorry that was so short, but thank you for listening to me. And again, if you have any questions, please feel free to reach out.